Okay, the numbers are increasing fast. Let's give it a minute for everybody to join, and then we can start. Okay. Wait a minute. Okay. Good morning, everyone. Welcome to this edition of Data at Breakfast. It is sorry, I always forget to say who I am. My name is Francesco Petruccione, and I invented or started this series of webinars more than 2 years ago. In the meantime, originally there was a real breakfast attached to these events, but we hope that very soon we might be able to go back to that tradition as well. So this morning, we are very fortunate to have Dusty Donnelly with us. Dusty is at UKZN in the School of Law, and she's a lecturer on the Howard College campus. She's also an advocate in the High Court of South Africa. She published several articles on contract law, insurance, and admiralty law. And currently her research focuses on data privacy. Yeah? And she's also doing at the moment a PhD on the same topic. Yeah? With us on the panel is Donrik Talda, who is also in the School of Law, and he kindly offered to moderate the questions at the end of the talk. Yeah? And Dr. Sinaisky, many of you already know him. He's my backup plan. So Ilya, thank you very much for that. Dusty, please, you're welcome to share the screen and start your presentation. Yeah. And as usual, at the bottom of your Zoom screen, there is a bar with a button for questions and answers, and you're most welcome to use it to pose your questions. So Dusty, thank you very much, and over to you.
Thank you very much, Professor, and hello everybody. Thank you for joining me today as we begin an important conversation about how we handle personal information in our online teaching and research. The Protection of Personal Information Act has been on the statute books for 7 years. In fact, it has its genesis almost 20 years ago, but the substantive provisions only came into operation on the 1st of July 2020, and there's still a 1-year grace period, during which time all processors must bring their processing into line with the Act. So what I will do today is I plan to set the scene and then provide an overview of the key provisions of the Act. And then I will touch on 2 common misconceptions that perhaps will spark some questions or debate. The idea that there can be broad consent and the notion of an anonymous participant. And lastly, I hope to leave you with some practical guidance if you are a principal investigator or a lecturer in higher education. What I'm going to say today will be pitched at the level of general information. I will assume that some of you or most of you will have little or no prior knowledge of the provisions of the Act. And so I hope you'll find this useful as an introductory conversation starter. But at the end of my slideshow, I've included some references for further reading. So what we see on the screen in front of us is The Great Hack, a Netflix documentary. And I think there's hardly anyone in the audience today who's not heard of the Facebook Cambridge Analytica scandal that erupted in the mainstream media in 2018. As we know, Cambridge Analytica harvested the personal data from at least 87 million Facebook users, and they used it to profile voters and deliver targeted messaging to influence Trump's election in the US and possibly the Brexit vote in Britain, amongst other things. So a truly frightening and somewhat dystopian picture of the power of collecting and amassing vast amounts of personal information. Those who are interested in the background, there's also a book out on Audible. You can download the audiobook as well, called Targeted by Brittany Kaser. And that is the whistleblower's inside story of the Cambridge Analytica scandal. And there are a number of other contemporary accounts, Shoshana Zuboff's Surveillance Capitalism, and the former US Secretary of Homeland Security, Mike Chertoff's Exploding Data, and many other easy reads that provide an introduction to this new world. But if we look back to the genesis of this, we see that the scandal actually had its origins in university research allegedly exploring how people use emojis to convey emotion. I'm of course referring to the Facebook app, My Digital Life, which was a type of personality quiz, that these things are popular on Facebook, developed by a Cambridge academic, Alexander Kogan. Now, Kogan reported that personal messages harvested off Facebook by the app were only used for research into how emojis convey emotion, but the app data, public profiles, but also likes, birthdays, address information, etc., was then sold to Cambridge Analytica. Even if it didn't include the personal messages, that was still personal information and undoubtedly an invasion of privacy. The app was a copycat of the My Personality app, developed some years earlier by Cambridge academics Kosinski and Stilwell, and they had published a number of original peer-reviewed papers. Their own website lists their stand for data privacy, although the media reports that they offered originally to sell the IP to the app to Cambridge Analytica for $500,000 US to fund further research. So as we see, there are very complex ethical issues that arise in relation to data, which now has huge commercial value. Clearly, as I mentioned, it was an invasion of privacy. The sale of the information without consent was unlawful and unethical. But it started earlier than that with the principle of data minimization that is so problematic in this era of big data, where the app collected more personal information than was necessary for the research project's objectives. And that was a problem with the platform. Facebook's Open Graph platform at the time, it has been changed now, allowed third-party apps to collect vast amounts of personal data and automatically also harvest the personal data of friends of persons who had installed the app. So what? Well, let's start with the very big picture here. That the whole of data protection law in all of its instances across the world is underpinned by the right to privacy, which is protected in South Africa under Section 14 of our Constitution. And of course, is also very closely linked to a number of other rights, principally the right to human dignity and autonomy in our decision making. We don't like to think of ourselves being manipulated and influenced covertly or being under surveillance. The right to privacy is not absolute. It is subject under the Constitution to justifiable limitations. And in the Protection of Personal Information Act, which I abbreviate on my slide here to POPIA, those limitations are expressly mentioned as well. So other rights, but also important interests, including the free flow of information, must be taken into account in a form of a balancing exercise between the data subject's right to privacy and, of course, the important and useful functions performed by data processing. And I mention that the title of the talk is perhaps a misnomer. I called it data privacy, but you will have noticed that it is the protection of personal information. And not all personal information will be private. We do, however, need to be sensitized to instances where our research involves a heightened privacy risk. And that will be when we are handling sensitive information. I'll deal with that later. the Act talks about special personal information and the information of children, but also certain types of processing, which include profiling and automated decision-making, on which there are specific provisions in the Act, and big data analytics and AI, which pose particular problems. These are complex, potentially invasive, and vulnerable to misuse and require special precautions. Now, if you're asking what the law defines as private information, the answer is that privacy cannot be defined in the abstract, and that comes from various judgments, including Bernstein versus Bester in our Constitutional Court. The guiding principle, which applies in an offline and an online environment, is that something is private if an individual has a reasonable expectation of privacy. And of course, as this radial graph attempts to illustrate, what one person regards as private may differ to someone who is more privacy sensitive. But at the core, there is what our courts call the inner sanctum that is always inviolate, the home and highly personal matters. And then as one moves out in concentric zones, the privacy interest becomes attenuated, and that balancing act that I mentioned then has to be performed. So one can have a privacy interest, for example, in your place of work, and there's case law from the European Court of Human Rights on that. One can also have a privacy interest even as a public figure who is out and about, so that there have been successful cases brought by such persons to protect photographs of themselves that are private. Now, the second point I'd like to make today is that research ethics and data protection law are not the same thing. They are both aimed at preserving the privacy of the research subject, but they may, in fact, have different requirements, and one must, as a researcher at UKZN, comply with both. So our choice of research topic and the conduct of research must take place in accordance with university policy, and it's the responsibility of the individual researcher to ensure this, and of course of the principal investigator to make sure that their team are on board. So one would make reference in our context to our ethics policy, but also to other policies like the intellectual property policy, contracts and grants policy, and also in our particular fields to professional codes of conduct that may apply. Research ethics is university underpinned by the concept of informed consent from the research participant. And although we are moving towards open access and the publication of our data sets, that does not override the right to confidentiality and privacy of the individuals or organizations who are the subjects of our research. So this requires careful thought when we release data sets as to whether we are protecting those identities. Now, the legal framework. As I mentioned, the South African Act is the Protection of Personal Information Act, operative on the 1st of July this year, but with a 1-year grace period for compliance. But to briefly set the scene internationally, the legal framework is a complex network of overlapping instruments. In blue, I've referred to some international instruments. There is a Council of Europe Convention on the automatic processing of personal information. South Africa is not a party to that convention, but many of our Act's principles draw on the provisions of that convention. Similarly, our Act draws on the OECD privacy guidelines. The African Union has a convention on cybersecurity and data protection, but it is not yet in force. It has only been ratified by 5 countries to date, I think. If we look overseas, the picture in Europe is probably one you're more familiar with. You've probably heard of the General Data Protection Regulation, which became operative in May 2018. Of course, in each country, there will also be national laws. So, for example, in the United Kingdom, they will have their Data Protection Act. That act must comply with the GDPR, save where derogations are permitted by the regulation. So the national laws are permitted to derogate from the GDPR in certain instances, and one must check both the regulation and the national law, as well as the ethical guidelines and professional codes of conduct that apply. And then if we look at the yellow in the US, the position is also complicated because at a federal level, there is no privacy statute or omnibus privacy statute that governs the private collection and use of data. There are sector-specific statutes such as HIPAA, which applies in health services, and FERPA, which applies to educational records of federal educational institutions. And the ones that I've listed there is COPPA, the Children's Online Privacy Protection Act. But something to be aware of, particularly for those of us who have children of school-going age, is that many of the mobile apps that our children will be using for schooling or entertainment purposes are not developed in South Africa, of course. Now, the protection of children varies substantially across the world. South Africa, a child is anyone under 18. But in the US, under the COPPA, it is anyone under 13. And in the EU, it is 16, but member states can provide for a lower age of 13 or above. The other US statute that you've probably heard of is a Californian statute, which applies then, so there's federal law and then there are state laws. And California has taken the lead on data privacy. And after, it's always had CalOPA, the Online Privacy Protection Act, which provided for privacy policies and such, but now has a much more comprehensive statute, the California Consumer Privacy Act. Broadly, there is an area of overlap in the center of all these instruments where they all espouse a set of broadly similar data protection principles. But of course, they differ in their details and they differ in their enforcement mechanisms, so that compliance with multiple statutes can become quite complex. One example, if you were doing research funded by a European funder who required you to comply with GDPR, or if you were collecting any information about EU residents, you would have to comply with the GDPR. So I've set the scene, and now I want to take you briefly through the key provisions of the Act. The first key term is personal information, and it's defined very broadly by the principle that it is any information relating to an identified or identifiable living natural person. So it doesn't apply to deceased persons, but what is unique with POPIA is that it does also apply, where applicable, to existing juristic persons. So as with our ethics guidelines, if you're collecting information from natural persons or juristic organizations, you must take cognizance of the protection of their information. And that is the data subject. So the Act lists a number of examples, but it is not a closed list. We see race, sexual orientation, health, consciousness, and belief, for example, but also biometrics, so DNA, fingerprints, retinal scanning, voice printing, location data, which of course is becoming increasingly important and, as we know, can be tracked through a number of ways. Traditional address information and contact information, but also online identifiers. And that term is not defined in the Act, but as I mentioned, the list is not a closed list. And the Act also talks about any other particular assignment to a person. So probably personal information includes an IP address, a persistent device identifier, and in the context of Internet of Things, devices like smart meters, which are attached to a particular person or their household, and identifying numbers, even a person's name if it's linked to personal information. Then the key actors, the responsible party in our context would be the researcher and probably UKZN, because it is the person alone or jointly with others who determines the purpose and means of processing. That means the researcher who determines what data they will collect and why, and how they will analyze and publish the data, is a responsible party under the Act. An operator under the Act, and these terms are used differently in our statute to other international instruments, so be careful of differences in terminology. For our Act, an operator is essentially a service provider, not an employee or someone under the direct control of the researcher or responsible party, but rather any person processing data on behalf of the responsible party in terms of a contract, but not under their direct control. And lastly, the data subject, who's the person to whom the information relates. And here, just be aware that this may be different to the research participant. The legislation will apply to the person about whom to whom the information relates. We look at the scope of the legislation. Again, it is very broad. The term data processing includes any collection, use, or sharing of personal information. So if your research involves personal information of any kind, you are probably processing that information and must comply with the Act. And I mentioned at this point, although I won't speak much about online teaching, the Act does not apply only to automatic processing. Again, this is something different. For example, the Council of Europe Convention that I mentioned earlier does apply only to automatic processing. But other instruments such as our Act and the GDPR also apply in an offline context. And everything that we do at UKZN that involves collecting personal information or processing it in some other way then must comply with the Act. So even when we are collecting, for example, a paper-based AgriTat form from a student in which they share health information as the reason why they did not attend a test, that is special personal information, and we must take steps to ensure that it is protected. But automatic processing, as we know, whenever we are online, there are now new risks related to location tracking, cookies, AI and algorithmic processing that pose new risks that we need to consider. And lastly, just to mention here as well, that if your information will be transferred outside of South Africa, you must ensure that there are adequacy guarantees for data protection in place that are at least equivalent to the protection provided under our own Act. I will not spend long on the conditions for lawful processing, but they are important to know, and there are 8 of them in our Act, broadly similar to the principles, fair information principles that apply in the US and the principles in the international instruments I mentioned. Accountability is the key principle. The responsible party, in our case the researcher, is accountable for ensuring that all conditions of lawful processing are observed at all times throughout the processing. There is a condition of processing limitation, and this is where we see the concept of data minimization, collecting only or processing only what is necessary to achieve the purpose. And having a lawful basis for doing that, which in many cases will be the consent of the research participant. Purpose specification, further processing limitation, which I'll come to, information quality, openness and transparency, security, and data subject participation. The data subject also has a number of rights: the right to have data lawfully processed, and this includes receiving notice of collection, requesting access to records of personal information that you hold about them, confirmation of whether you do hold such records, the correction or deletion of those records, and to be notified of a security breach under Section 22 as soon as reasonably possible if there is reason to believe that an unauthorized person has accessed the data. The information regulator and, where possible, the data subject must be notified. Now, the basis for lawful processing, I think it's important to understand, can be any one of these 6 set out in Section 11 of the Act. Consent is only one of the grounds for processing personal information. I won't go into the others in detail, but I will mention that a public institution such as university processing information in terms of a public duty, or any party processing information within their legitimate interest is also processing that information lawfully. Lastly, to wrap up the provisions of the Act, if you fail to comply with ethical obligations, you of course face disciplinary procedures from the university, but if you fail to comply with the data processing law, the information regulator has wide powers to monitor and investigate and receive complaints. And there are offences under the Act for which the penalties are imprisonment for up to 10 years or a fine of up to 10 million rand. So the key message that I want you to take away from today as a researcher or lecturer is that there is no blanket exclusion for research. The only exclusions under PAPIA are for purely household processing and for journalistic, artistic, and literary processing. There are relaxations for researchers around the provisions for data retention, notice, and further processing. I will take a little extra time to run through those with you, but as a general principle of interpretation, I would suggest that our courts will approach these as exceptions, and exception clauses in a statute are always narrowly interpreted, which means we must exercise caution and, when in doubt, act in the spirit of ensuring the research participants' privacy. So personal information may not be retained longer than is necessary for the purpose. PAPIA says it can be retained longer than this for research purposes, but only with appropriate safeguards. So, for example, we may retain research records for 5 years, but there must be safeguards about where the data is housed, who has access to it, and other security measures. This is important, the provision for further processing. If one has consent for a primary study from the research participants, and you want to use that data for a further study, it's permitted if it is compatible with the original specified purpose. That's a general principle in the Act, but it further says that it will be not incompatible if the data has been deliberately made public or it is used solely for research purposes and not published in identifiable form. So just a word of warning here around public information. Just because you have found the information in public does not mean that it has deliberately been made public. You need to be very cautious of the context in which that information has been publicized. For example, on a social media platform, the privacy settings, or if there was a limited audience for a particular post, it has not been deliberately made public, and there's still a privacy interest in that information. And you need to be aware of any conditions of the publisher. So don't assume that information that you found has that in the public domain can be used for research. Best practice is to notify participants. The example mentioned in the slide comes from the European Commission Guidelines on Ethics and Data Protection, a very useful document which provides a great deal of detail on how to apply GDPR. If, for example, one had original consent from 50 subjects for a particular project and later discovered that the data was useful for another project, focusing on mental health under the coordination of a different team, but still within the same university, the principle that this further processing is compatible would apply. Yet the European Commission notes that the university still contacted the data subjects to notify them of the further study and obtain fresh consent. And that is under the principle of fairness and openness and their own ethics policy. So where possible, consent remains the gold standard for ethical research. Lastly, Papier says that notice of data collection is unnecessary if the information is for research and will not be published in identifiable form, but this doesn't override institutional ethics review. These are the types of special personal information for which you must observe special precautions. You'll see children, health, political persuasions, race, a number of other factors are listed in Part B as special personal information, and Part C has provisions relating to children, anyone under 18. In brief, you require the consent of the data subject, or in the case of a child, their parent, but again, there is a limited exception for research if it is in the public interest or if it is impossible or requires disproportionate effort to obtain consent. But in both cases, there must be sufficient privacy guarantees. It's also permitted if the data has deliberately been made public. So if we look for some high-level guidance, of course, we don't yet have guidance from our own information regulator, but in Europe, GDPR now distinguishes between data collected from the data subject where notice must always be given. And so impossibility or disproportionate effort will typically only arise when you are not collecting it directly from the data subject. For example, when research data is being used for subsequent research projects. And in those cases, there must always be a carefully documented balancing exercise of the effects of providing notice and the impact and effects on the data subject of not providing notice. Some examples provided by the Article 29 Working Party on Data Protection and the EU Commission involve studies where there's large volumes of data or where the age of data makes it impossible or disproportionately difficult to provide notice. And some examples of the kinds of safeguards that we could apply would be to make information about the research publicly available, to ensure that there are technical and organizational security measures in place to protect the privacy and confidentiality of the data, working with pseudonymized data, minimizing the collection and retention of personal data, and in projects that have a high risk of privacy impacts, always to have a documented data protection impact assessment. So just two touch points are topical issues in the research field. Can you have broad consent? In short, no. The concept of broad consent, in my opinion, is a misnomer. Because broad consent means that the research subject is providing consent to some vaguely specified future research purposes. And if we look at the definition of consent in our legislation, it must be voluntary, of course, but it must also be specific and it must be informed. And it cannot be specific and informed if the participant hasn't been told about the research and can understand the implications for them of participating, and have the right to withdraw their consent. But as I mentioned, consent is not the only lawful basis for processing. There's been some, shall we say, spirited debate here and internationally on this topic in the field of genomics and biobanking. And so I've included in the references a publication by Beverly Townsend and Don McVeldo in South Africa, and that publication then references a number of other publications in South Africa on this point, and also a publication by Staunton, who has discussed the position under the GDPR as well. Second challenging topic, there's the concept of the anonymous participant. And again, I suggest that when we tell our participants that you will be anonymous, in many cases, this is not correct. Pseudonymized data and aggregated data, I say it may still be personal information. This term, pseudonymized data, quite a mouthful, does not appear in our Act, but is in the GDPR in Europe. And it means that personal identifiers such as names have been replaced with non-identifying codes. In the case of online, we may have called hashed data. And of course, aggregated data or statistics depends on the level of granularity. It might still be possible to identify an individual. So in both cases, remember the underlying principle is that data protection law applies unless the data has been de-identified. It is completely anonymous. And the principle is that it must be deleted unless it cannot be used or linked with any other data set by a reasonably foreseeable method to re-identify the data subject. So today's overview, we don't have time to talk about this, but there are a number of studies showing how difficult it is to in fact truly anonymize data. The standard techniques of simply pseudonymizing data and replacing names with codes is not anonymizing the data. Somewhere a code sheet continues to exist with the personal information. But even in releasing sampled anonymized data sets, a recent study showed 99.9% of participants could be correctly re-identified. And this study is included in the list of references. To wrap up on this point, it becomes complex because there's no one size fits all. Different obligations can apply. One must be aware of two things, timing. So if you collect personal information and then anonymize it, your study is not truly anonymous. The data protection laws will still apply, at least at the point of collection, until the data has been de-identified. Also, there may be different parties using the data. For example, when a host institution shares an anonymized data set, the recipients, so possibly a secondary study, may be exempt from data protection law if there's no risk of re-identification, but the host institution retaining the raw data must comply fully with data protection law. So I think it's useful for us to start taking this conversation back to our faculties and developing within our disciplines proper procedures and codes of conduct for handling personal information. I have suggested a number of questions that a principal investigator needs to ask, starting with the obvious: will the research collect any personal information? And is any of that classified as special personal information or the information of children? And also, where will we collect it from? Is it directly from the data subject or from a public record or other? And what is the lawful basis for processing? And in all cases, we must be very clear what the purpose of processing that information is and whether it is necessary to collect personal information for that purpose. If it is not necessary, the principle of minimality is that ideally we should not collect that information. We probably also must look at the security of data more closely. It is part of data protection, not the whole of data protection, but an important part. And in an online environment, and this relates also to online teaching, we must be aware of whether the tools and software we are using are data privacy friendly. We have to get into the habit of reading terms and conditions of service providers and software providers to make sure that they have adequate privacy and security guarantees, and having secure communication and storage protocols like data encryption. I have not touched, and I will close now with the next frontier. Perhaps our participants can share some of their experiences, but artificial intelligence, machine learning are the next frontiers. And here we have big challenges, not only in relation to ethics, but from a data protection point of view with data minimization, simply because of the large volumes of data that are collected to train algorithms, and with the principle of openness or transparency, primarily because it's almost impossible to explain algorithmic processing in terms that the average person can understand. And again, I've included some references to the OECD AI guidelines, or principles rather, and to the Council of Europe's latest reports on how to overcome these challenges. So I hope that you have found this interesting. I apologize that I did go a little bit over the 30 minutes time, but this is an important conversation and we have a year to take it forward. The regulator can approve codes of conduct. The regulator can provide guidance on whether we are complying with the Act, and even issue exemptions if a particular professional sector or research sector wants to approach the regulator. They can take this up under Section 40 and 37 of the Act. But we also need at an institutional level to develop our own data protection policy and start promoting training and awareness in our faculties. Thank you.
Yeah, Donnelly, thank you. Thank you so much for a very informative talk, spanning the range from the principles of data protection to the checklist that we can make use of in everyday life to make sure that we don't commit any data crime. Donnelly, over to you. I see there are several questions, and please, you can start the moderation now.
Indeed. Hello, everybody. We look forward to your questions. I will start with the questions that were posed in the little Q&A app here on Zoom. The first question is the following. I would like to ask, how does the law apply to those who post on social media images of accidents and deceased people after violent acts such as murder?
Such an interesting question. Social media is posing major problems with the traditional concept that there are three actors: a responsible party and a data subject. Because if you are a social media user, you probably think of yourself as the data subject. I have a right to have my personal information protected by Facebook or Instagram or whatever other platform you're posting on. But in fact, you have two roles, because if you are posting personal information about other people, you are a responsible party. So in theory, the Act applies to you, and you must make sure that you have a lawful basis for sharing that personal information. There was an interesting case before the European Court of Human Rights under the 1995 Data Protection Directive when it first became operative. Mrs. Lindqvist, I think she was in Sweden, or created her own private website for her church, and she felt it would be fun to put on there the profiles of the fellow members of the communion team. She included information about a little fall that one of the members had had and that she was recovering nicely, and other personal information, tidbits if you like, about members of the team. She didn't have their consent, and the court found that she had breached the data protection law. So one has to be careful with what you post online. And also remember that defamation laws apply, not in the context of posting pictures of accidents, but for any social media posts, exercise restraint.
Thank you, Dusty. We'll go on to the next question. One of the participants asked about intellectual property infringement, but I think that's a little bit, well, that's outside our frame of reference, but I think we can make a note with Francesco that can be a topic of a subsequent conversation of intellectual property infringement, but that's something quite removed from privacy, of course. Then one of the participants asked about guidelines on POPIA and GDPR by the universities in South Africa. I don't know, Dusty, whether you're aware of whether universities in South Africa has, whether universities have issued such a guideline.
I am not aware. I couldn't find a guideline for UKZN. I see we have, no, we don't. I couldn't find a guideline from a South African university. I included an example from the University of Leicester in the UK in my references. I think we now need to use this year to produce those guidelines and policies.
I see one of the panelists is commenting that universities of South Africa are apparently in the process of developing such guidelines.
Yes, we did roll out some training about 2 years ago. Perhaps some of our members here who are on staff were part of that training, but it did not, in my opinion, go nearly far enough. In fact, at the time I wrote to the registrar to suggest we must deal with this in a great deal of detail, because every aspect of what we do is covered by the Act, not just our research and not just online, everything online and offline that involves personal information of staff and students.
Yeah, no, absolutely. That's a very important. One of the participants asked about how would private and public sector companies and organizations manage under POPIA, such as Telkom and the municipalities and cell phone companies and so on. Well, they had a long time to prepare, you know, since it was enacted in 2013. What do you think, Dusty?
Look, I think private companies have probably been preparing for some time, and in the mobile communications sector, you know, the electronic communications sector, companies have already had to get to grips with RICA, so they will probably be well placed. I mean, the bottom line is they have to comply. The question I see in the Zoom chat is, does the information regulator have the capacity to deal with enforcement? I think that is probably the bigger question. I mean, we see in Europe that they've had data protection laws on their statute books for over 60 years, and still we see that the problem lies with enforcement, and it lies with a coordinated enforcement. It becomes quite tricky in such a complex environment to develop effective, coordinated rollout of these principles. I think another big question, perhaps, Donrick, is small business, how small business can comply.
Absolutely. I think that's actually because big business are supposed to have all the resources and legal teams to assist them. But what about small businesses?
Yes, well, you know, this is interesting. I mean, our small businesses are, in the COVID crisis, have taken a huge hit. So for them, this will be a concern, just another headache. But there is no exemption in our Act for small businesses. And that's pretty much standard. There is, for example, in Australia, they've taken the approach of completely exempting small businesses from certain aspects of compliance with the Australian privacy principles. But many people argue that the size of the business is not what really counts, because one can have a very small biotech startup that is collecting special personal information, highly sensitive, and so it may qualify as a small business, but in fact pose a high privacy risk. So that's the approach in Europe, is more of a risk-based approach. So generally speaking, the regulator should probably provide some basic guides that would be simple to implement, basic measures that all businesses should be doing anyway as good business practice, but identifying sectors that require more intensive scrutiny because of the heightened privacy risk. And I think hopefully consulting with those sectors and developing codes of conduct through a consultative framework that takes into account how they operate.
The issue of enforcement was raised, and I think we touched on it. But I think we must also remember, in the South African context, even if the information regulator doesn't actively enforce the provisions of POPIA in a certain sector, for instance, private organizations, for instance, NGOs or interest groups, can still approach the court and enforce these rights in the public interest, similar to what we saw with the treatment action campaign in a decade or so ago with the issue of HIV and the MRC, that didn't, as the regulator, actively enforce measures against people who would, for instance, make statements that certain vitamins would heal or would cure HIV/AIDS and so on. So in that case, the treatment action campaign simply went to court and got an interdict against those people who were spreading these statements, and also an interdict against the regulator to actively enforce and to actively fulfill its mandate to regulate. So those things are possible.
Yes, that's very true.
Yeah.
I think that is probably the trend we see in South Africa, and a good one of activism. I think recently the Black Sash, if I stand to be corrected, actually joined as amicus curiae in the litigation involving the payment of social grants and cash paymaster services, who were harvesting personal information from grant payees. And I mean, this is a vulnerable population who are now being potentially targeted with loan offers and such. And the information regulator was joined in that litigation. So there are means, and the Act also provides for the data subject to bring civil action for damages for breach of the data protection law.
There are a few very interesting questions here. I will start with this one, posed by Professor Bosch. Are there relaxed rules that apply with the collection of personal information in cases of times of health emergency like COVID-19?
I don't know. I assume that you know, the government would do what they've done now and act under the National Disaster Management Act. And the question would then be which trumps. No, the POPIA itself contains provisions that allow processing to be non-compliant in the public interest, and that would cover probably that scenario that Professor Bosch is referring to.
Yes, I agree with that. We must just remember that the initial collection of information is not the end of of the duty of the researcher. Every single time that you share it, that you do something new with the data, you need to comply. So, for instance, post-COVID or post the emergency, you might still be doing research on data that you gathered for the COVID crisis, but when you decide to share it with another research institution, either in South Africa or abroad, or do new research on it, you need to comply again. In other words, you need to then reconsent your data subjects, your research participants.
Oh yes, absolutely. I think perhaps I misunderstood Prof. Bosch's comment then. There's no exemption at all for private researchers such as the university researchers. COVID-19 has required us to forego face-to-face collection methods in favor of perhaps online collection methods, but we must still remain fully compliant with the Act. Of course, one can collect consent electronically. It can still, there are many ways to do this and make sure it's informed consent, but we must comply with the statute.
Yeah, and it's important that that consent is specific. In other words, it can't just be upfront to consent to whatever happens in future. It must be consent to a specific research project or to a transfer or whatever the case may be.
Yes, well, this is the difficult debate because one doesn't want to stifle academic research by imposing unrealistic consent frameworks for each and every project. So there is this exemption, and it was in the 95 Data Protection Act, and it remains in GDPR as well. For compatible further purposes, one can regard that as lawful processing without specific consent. But in each case, for each project, the researcher must be very clear on what basis am I claiming that my use of this data is lawful, and be very careful if there is no informed consent.
Then there's another very interesting question, namely, are there tools available that we can use to protect existing pseudo-anonymized patient data? If I can just start with the comment that I know that often in the health sciences, information would be collected, say, at a clinic or by field workers, and they will keep an original spreadsheet that will have the names, the contact numbers, and then a little code that's allocated to that sample, and then the data, or let's say the spreadsheet that's provided to the researchers in the laboratory who's going to do the research doesn't have a personal identifier like the name. It will just have that little code. So the researchers themselves will work with anonymized data, but the original spreadsheet, it's called the master document that connects the code with the name, that is still kept, perhaps by the clinic or by the management or so. So I think in that context, people must just understand that that data isn't anonymized or isn't de-identified, because that original spreadsheet still exists and it's in the possession of the university. But what can be done to anonymize or pseudo-anonymize, I think, is the word that the participant used here.
Look, that's probably outside of my frame of reference to speak specifically on protocols in the health sciences. I don't want to tread outside an area where I have any expertise. Safe to say that even the pseudonymized data set where one has replaced actual identifiers like names with a code, for example, must still comply with POPIA. That study I referred you to shows how easy it is using certain demographic markers to identify patients. There was another study where a sampled subset of health data was released, and researchers were able to re-identify a number of public figures, identify their sexual orientation and certain genetic conditions from the data. One needs to be careful. I can share the presentation and suggest further reading, starting with general principles from the Article 29 Working Party on anonymization techniques. But there's a lot of work happening well outside my frame of reference on differential privacy techniques that take this further. And I think that is where the new frontier of research is on using differential privacy techniques like K-anonymity and L-diversity and those kinds of approaches to data to achieve true anonymity.
And another interesting question, a third-party researcher requires access to your data set. How does POPIA apply?
It applies because giving access to the data set is processing the data. So that when you share it with a third party, you're processing the data. You need to make sure that your actions fully comply with POPIA. Do you have a lawful basis for sharing it with that third party? One lawful basis would be consent. Have you informed the data subject that you will share it with this third party? Have you identified the third party, or at least the category of third parties that you may be sharing the data with, and what purpose will they be using it for? Remember that the limited relaxations apply when you're using it solely for research purposes. So do you have that assurance from the party receiving your data? Contracts and data sharing arrangements need to deal explicitly in detail with these considerations to make sure that you've got the contractual safeguards in place.
I think we're slowly running out of time, I see, but there's a very important question just posed here that I think would create a lot of clarity. The question reads as follows. If you are totally anonymizing data, I suppose the participant means if it's de-identified, how can a participant withdraw from a study? That is what our informed consent forms says the research participant can do. Surely you need the list of actual data and anonymized codes to be able to do that. Well, I think the obvious answer is yes. If you want to give the participant the right to withdraw, then you need to have that original list. But I think, Dusty, what you can just go in, I think it's essential to understand that POPIA isn't just a one-way street with one option always. For instance, something like de-identification is an option, and then POPIA will not apply. But if you don't decide to follow that option, then there are actions. As you've said, there are legal grounds for processing. There must be a legal ground. Consent is one of those grounds, but there are other grounds as well. Perhaps you can just elaborate on that.
It's such an interesting question, and it perfectly wraps up today's discussion, the difficult dilemmas. I think what I mentioned at the outset answers it, which is that POPIA is a framework for minimum compliance. One must, at a minimum, ensure that your processing complies with the data protection principles. But ethical guidelines, research ethics review boards, funder, grant funders can require you to retain the raw data and or give participants the right to withdraw from the study. I mean, POPIA gives them the right to withdraw consent. So you will probably be retaining that raw data in some form, somewhere for the specified period in the approval of your research ethics application. And then it requires you to comply fully with POPIA, as well as with whatever terms your research ethics approval stipulated. If your research ethics committee stipulates more stringent terms, then they must be complied with. POPIA is basically a minimum threshold for data protection.
Great. I think, Francisco, we've run out of time, so over to you again. Thank you.
Thank you very much, Donnelly, for a very time-precise managing of the questions. And I think we all saw from the many and very interesting questions that the topic is really timely. Yeah. And many of us have to learn a lot probably to comply with these regulations and make sure that we don't do silly mistakes. So, so Dusty, thank you so much. And I'm sure we will ask you in the near future to give us a follow-up lecture on some other aspects of data privacy. Yeah. So one of the things that we learned today is that when we go back to our work or our daily life, we don't only have to protect ourselves from COVID, we also have to protect our data very closely, keep it very close to our chest. So Dusty, thank you so much. Donnelly, thank you very much for your assistance. Ilya, thank you for the backup. And I would also like to thank, because very often I forget, the people in the background that make all this happen. Yeah, people like Kimara, Nelly, and Rene that bombard you with emails to remind you that we have a data breakfast. So thank you very much, everyone. Have a good and safe day, and enjoy the weekend. Thank you very much. Bye-bye. Cheers.
Bye-bye.
Bye.